Hello, everyone, and welcome to this episode of Inlay Terms. I am your host, Payman Ascari, and our guest today is Mr. Mark Fields. Mark, welcome to the show.
Thank you for having me, Payman.
Thank you for volunteering your time. We're going to go into some detailed discussions about law today, correct?
Yes, yeah, I'm excited to have these kinds of conversations. I think, maybe I'll say this. I came across a quote by George Washington, and George Washington said, the purpose of one of the purposes of government is to educate its public on the signs of government. The signs of government meaning what are the rules of governance? What's the structure of society, essentially? And I think if there's any complaint I have about, there's lots of complaints I'm sure we can all have, but one of my biggest complaints is that we don't do that. We don't educate ourselves. We're not educated on the science of government or governance, and what is the fabric of society? What is it that binds us? And so, having these kinds of conversations, I think, is a really important quality of any society.
I'm noticing this in the last few years now that I'm taking a more, active involvement in my country, how little I know, how little I knew, and I still know about the law.
Yeah, well, similarly, I don't know what inspires other people, but for me, 2020 happened and we have all these lockdowns, and regardless of why the lockdowns and all that stuff is happening, when it happened, it was the first time in my life where someone told me I can't do something, as in go work and make a living, and I didn't know why, and it was the first time I realized, man, I have no idea where my rights come from, who has the rights to do this, what is all this, and so you and me both, I was in that same boat, and then I committed myself to learning it. I put aside a lot of things in my life and devoted a lot of time and hours towards trying to learn and understand. And by no means do I think I've fully understand it. It's a vast field, but I do feel quite confident in the things that I've learned.
So I'm glad that our paths have crossed. Before jumping into the episode, could you tell the audience just a little about yourself? Maybe you're a bona fides.
Sorry, what was the last thing you said? Sorry.
Tell us about your CV, educational
Oh,
background, anything that's relevant.
I guess all I'll say is, I studied in the field of medicine and practiced medicine, and I've done tons of educational work in my life, and so I'm not new to spending a lot of time, devoting a lot of time to learn a complex field, or an in-depth field, I should say. And so when my interest turned to law, that was, it was easy and natural given my background was in educating myself in medicine, to devote that time to educate myself in law. And I was fortunate to connect with a couple of other really great Canadians, one of which I hope one time maybe finds himself on your show. Very learned man, and he helped guide me a little bit in terms of my learning, which really sped the process up, I think, for me. But I like you, I live here in Canada, and I wish for this country and for life in this country to be as good as it possibly can be.
So I guess let's wait until the end of the episode, and if I don't completely burn my bridge with you, I can ask you to introduce me to this gentleman, get him on
Sure.
too.
Yeah, absolutely.
All right. Well, let me bring up I guess you could say, our itinerary or our script for today. So the first question is the issue of the Statute of Westminster. When you and I were talking about offline, you brought this up and you were stressing the importance of it. So what is the Statute of Westminster, and what's the importance of it?
Well, I guess, to appreciate why this act even needed to pass and what it represents, requires us to cover some history. And most things in law requires historical context to keep in mind. So, I can, instead of going all the way back to the beginning, we can just go back to what was happening leading up to the Statute of Westminster and why it's important with relationship to Canada. And the reason why I bring it up is because I often come across people being concerned about, is there any legitimacy to Canada? Is it even a sovereign nation? Is it being ruled by the king? Is it, is a corporate entity that's being run out of the United States? I've heard these things, and I think anytime we sort of don't fully appreciate the full context of something, or we're missing, where there's gaps in our understanding, we tend to fill it in with beliefs. And so a lot of these end up being beliefs that aren't necessarily, that I hope to try to clarify. And this is why I brought up Statute of Westminster. So and law is an ever-evolving framework. So and it's always trying to fix an issue. So in the 1920s, the world had an issue. We had all these colonies of Britain that functioned under the legislative authority of Britain. Canada was no different. So the British North American Act was an act that was passed by the British Parliament. Although it granted a territory for the people living here to govern themselves, it was passed, the superior authority was in the hands of the British Parliament. But between 1867 here in Canada, but in general in the late 1800s, early 1900s, specifically after World War I, a lot of the colonies wanted to assert their own degree of independence, their own degree of authority in their own manners in life. Like before the Statute of Westminster, all the colonies were dependent on the British Parliament with regards to foreign affairs, with regards to even some domestic laws. Canada could pass a law for itself, but the British Parliament, if it was repugnant to the British set of laws, they can avoid it, essentially. And so post-World War I, nations of various different colonies of Britain said, we want to be independent. We want to have our own ability to write our own laws. And so that's what Statute of Westminster accomplished. The Balfour Declaration in various different conferences in 29 and 30 preeminated this. And then in 31, Statute of Westminster was passed, and essentially granting all the colonies of the British the legal autonomy. Essentially, they could be on equal footing with Britain with regards to how they're recognized, write their own laws, with the exception of two areas, mainly one area, and that's to do with the Constitution. So the original Constitution as it was written was written by the British Parliament. So they didn't have the right to amend or change anything to do with the Constitution. We can say a little bit more about that in a moment, but everything else they got the legal authority to.
I have a follow-up question for you. Can I jump in?
Yeah, absolutely.
Why did they not let them give them the power to amend their own constitutions?
Because at that time, it wasn't Canada's constitution, right? There was the British Parliament that wrote that constitution. Now, Sir John A. Macdonald, Cartier, and amongst others from Canada, representatives from Canada, were there to discuss what was to be written. But at that point, you can think of it at that point, 1867, BNA Act, at that point was more a promise. We're giving you this territory. You can govern yourselves. Okay, some more context. You have to remember, we are all subjects under the English monarch at one time. When the Norman conquest happened, King William stole the lands, made everyone his subject. And so then we have feudalism, and feudalism eventually ends, but we are still subjects under the British Parliament at this time. The government structure, no longer the monarch. So we are still subjects under the British Parliament. They gave us the monarch, or the Britain gave us this territory to essentially allow us to have a society for ourselves. And they passed the act. So that's why they retained the ability to, if any amending needed to happen with the BNA Act, it needed the consent of the British Parliament because it was their initial act. It's like if I wrote a book, I'm the author of the book, and Paimon, you come across and you want to change a chapter in it, you need to get my consent first. And so that's essentially why they retained that quality. It was a promise that Canada will eventually constitute themselves. And that's why there's a lot of different interpretations of what Pierre Trudeau meant. But one interpretation is that we did have a constitutional crisis. We didn't have our own constitution. We were functioning under a constitution that we agreed upon, but wasn't written by us as a group of people. It was written by British Parliament and their legal experts and their legal scholars. So it wasn't until 1982 that we actually fully constituted ourselves and retained the final capacity, which is to write and amend our own constitution and finalize the ability to write our own laws on all things. Up until 82, we didn't have the authority to write laws on everything. Until 1931, we had to write laws that was consistent with the British Parliament. After the Statute of Westminster, we can write more laws with the exception of anything to do with amending the Constitution or any sort of judicial decisions that were constitutional in nature. So we had the Privy Council. Privy Council had a judicial committee, and they were the final appeals court, essentially. In 49, that changed with the Supreme Court of Canada being established. And then in 82, when we formulated our Constitution, the ability to create our own Constitution was finalized. So you could say we got our full autonomy in 1982. But that Statute of Westminster was critical because that was the first time that the British Parliament, and obviously the world, because the world has to recognize any nation to do anything they want. And so if these are colonies of the British, and the British goes to the world and say, hey, listen, they have now full legal autonomy. This is a big deal in the world. So in 31, this was the first time all the colonies of Britain were recognized to be on equal footing as Britain, recognized as a nation amongst all the nations in the world, like China or Russia or US and Britain. Before that, we had all the colonies of Britain had a different standing in the world as a result of not having the same legal footing as Britain did. I hope that made clarified.
No, is that, I cut you off at some point. Is there anything else you wanted to add, or is that it?
I think I covered the things that I did want to add in your follow-up question, but yeah, if I did, it'll come back to me at a later time, I'm sure, as we're going along.
So as you were talking, I have another question. You mentioned that there was two things that we couldn't do after the Statute of Westminster. Did you answer what the second one was?
Any sort of final judicial remedies associated with the Constitution. So it was all around the Constitution. The first was amending it. The second was if there is a judicial issue regarding the Constitution, let's say you and I have an issue or I have an issue with the government and it involves the structure of the Constitution, the final say or the final appeals court, we can say, was with the Judicial Committee that was part of the Privy Council out of Britain.
So how did they manage to change that in 1944, I think you said, to create the Supreme Court?
In 49, we established a Supreme Court of Canada, and upon establishing that, the final say with regards to laws here were heard by the Supreme Court of Canada. I believe at that point you may have still need to go to Britain. I think you still had to go to Britain when it came to the Constitution, but we had established the highest court of appeal on all other matters. At that point, I'm a little bit foggy or not clear on exactly what, if after 49, if even there was a constitutional case, and if it did have to go above the Supreme Court of Canada, because I mean that's one way I would know. But I'm foggy to know at this point whether there was even a case that required to go after 49.
So I'm going to stray a little bit off the script that we established.
Sure.
Tell me if you agree with what I'm about to say. In the U.S., the people or whatever the leaders, they got together and they established three co-equal branches of government. And the Supreme Court, basically what I'm trying to say is that in the US, the legislature, the Congress, they can't just create courts. But I'm getting the sense that in Canada, our legislature can create courts.
I wouldn't. No, there's nothing that says the legislature can create courts. The Supreme Court of Canada Act was an act of law that. So this is another way that you can look at it. So the United States, when they had a clean break from being a colonies of Britain, they spent the time and wrote out a written constitution, essentially a code that govern their society going forward. That's one way that societies can come about. English law is if you go to England right now, you won't find a written constitution. And people will make the case that the Magna Carta was the initial constitution, or they'll say this is the constitution. One of the things that's unique about English law is that there's like an unwritten constitution. The constitution is made up of a collection of acts and decisions that have happened over time. So it's not written in a single codex, but it's found through the history and evolution of the law, which is, in some respects, it can make it really confusing because you don't know where to look. You don't know where sort of the North Star is to look to get all the answers that you need to get. Like in the United States, you can just look to the Constitution and its various different amendments to get everything you want to know about the codex of how to function in society in the United States. England wasn't necessarily like that. They have an unwritten constitution, and it's an evolving constitution. Canada was no different, and there's different nations that it's like that. But Canada and various other colonies were no different in that their constitution was a evolutionary thing that's happening. So even the United States, you said after the United States was formed, yes, legislation is creating and passing laws. They're not doing anything with the courts because the courts were divided through an act of law right from the beginning. But in the case of Canada, it didn't happen through an act of law right necessarily at the beginning. Although the BNA Act does mention courts within it, there's like an evolution that's happening within the nation, and as the evolution is happening, laws are being written to establish the framework of the society. That's up until 1982.
So yeah, you kind of preempted or predicted my next question, which is about the Privy Council. You mentioned the Privy Council was sort of like the last go-to branch for judicial issues concerning the Constitution. What is the Privy Council?
So the Privy Council, again, let's go back in history. How the Norman Conquest happens, King William takes over the land. This is my land. I'm ruling it despotically. He gathered around him his top knights, his top clergy members, his top lords, and created this sort of private council, sort of like you would see in Game of Thrones, to make decisions on how to manage his land. That when the Magna Carta was passed and a few acts afterwards, and Parliament, or the form of Parliament, was starting to be established, the Privy Council then became an aspect of Parliament. This private assembly of individuals, the high-ranking individuals. You got to remember, in feudalism, we had more than 20 different classes of people. You and I, Payman, not to assert anything about you, we would be serfs and peasants. We would have no say. We don't have a vote in feudalism, right? So the lords and the barons and the clergy and the knights, they would have a vote, and the highest members would be amongst this private council that helped make decisions for the king or helped support him in his decision making, and then finally Parliament. Over time, as government sort of evolved, we then start to have here in Canada, or even in England, we start to have a House of Commons and a Senate. So the need for a private council was that's separate from the cabinet was lost. You have ministers for each aspect of society now. You have the Minister of Foreign Affairs, you have the Minister of Agriculture, you have the Minister of Defense. They represent the roles and the duties that the original members of the private council of the king represented. So the Privy Council nowadays is really mostly an honorary thing that to be consistent with how the system of law in England was established and how it's continued. The Privy Council is made up of the current ministers and all past ministers. So that's why you can sometimes have opposing party members within the Privy Council. They're made up of chief justices and retired chief justices, and sometimes notable public servants, people within the public who've contributed greatly. But mostly they don't really meet. And if they do meet, it's usually when for example, King Charles comes to town, they have a formal meeting that gathers all of them. The primary meeting of the Privy Council is of the current ministers in Parliament right now. Under Mark Carney, for example, the current ministers would be the one who would be sitting and having meetings. And no longer is it really required to be in a Privy Council, so to speak, quote unquote, in the private collection of individuals that happens within the House, and the discussions happen. There is the formal, when the British North America Act, because it was a British Parliament Act of law, and final authority remained with the King / the British Parliament, the representative, really the head of state of Canada, had to be someone from the monarch, or representing of the monarch, which was the Governor General. So the Governor General still has a seat in the Privy Council and still signs off. But this signing off is at this point mostly just based on the fact that we've accepted a constitutional monarchical system. And if Canada ever wanted to remove the monarchy, they totally can. They can all vote on it and remove it. It doesn't play a significant role in the governance structure, or in terms of what happens. So the Privy Council is something that was originated during feudalism that we sort of still have around, but it really doesn't serve much of a purpose because the function of government has expanded. The people within government are publicly chosen to be representative of them, and all the mostly interactions are happening in a public forum for the public to see. Back in the day, when the public had no say because they're all technically slaves or subjects to the king, it happened in private chambers with the king, and that's where the term Privy Council originated from. It has some backgrounds in the Roman Republic with the Cura Regis. I think it was in Latin what it was called, but in England they called it it got the name Privy Council.
It's good to see we have another useless department within our government.
Yes. Yeah, exactly.
All right, on to the next question. I'll bring it up. Is the act I don't like because it's difficult to pronounce, the Judicature Act. We're not going to, we decided that it's going to be too time consuming to really go into it, but you mentioned something. So law of the land is a term I've heard. Law of the nation, that's not a term that I'm familiar with. Can you give us a breakdown of both?
Yeah, so the laws of the land are you can think of them as the foundational principles that govern society today. If you go to China, or if you go to Russia, or if you go to US, or if you go to Canada, there's foundational principles that govern each society. Those all these nations have adopted, or as it's used in English law, received English law as their foundation. And one way you can tell this is if you just go look at the property titles. For example, the highest property title here, you can have fee simple. Fee simple is a feudalistic term that English law created that established who has what right to the land, essentially. So the foundational principles that govern society are the laws of the land, and they're the laws. One way you can common law has many different ways you can interpret the word, but one way you can interpret it is all these laws to the land. If you look at every single act, and by the way, there's a book that traces every single act that's been passed from the beginning of the Norman Conquest to today, of which that I've read through. And if you look at the progression of all the acts, every single act that's passed is talking about a lot of things, but at the heart of most of it is creating a set of rules with relationship to the land. Ultimately, when William stole the lands with the Norman Conquest, he established a particular kind of feudal landholding. And that persists today. And that's the foundational quality of every single society on the majority of the planet. The laws of nations is all the laws that the nation is now establishing on top of those common principles, common ground rules, you can say. It's the icing on top of the cake. The cake has been made and has been baked, and we have not had any new laws be added since 1925, and we will not have any new laws added on top of the foundational principles of society. But the icing will change, and every nation is changing their icing all the time. That's the laws of the nation. So Canada has its own set of laws for their people living in society, but they cannot change any of the foundational principles. And in fact, this is written in the Statute of Westminster as well. So one of the things that happened in Canada, once they finally fully constituted themselves in 1982, if you look, there's been a number of different laws passed. Why? Because they finally got the authority to write all the laws for themselves, and they proceeded to write a ton of laws. This happened recently. Like Danielle Smith in Alberta wrote a Bill of Rights, essentially, for the province. And in many ways, you can look at that, and some people celebrated that because they felt like they were getting some rights from that act being passed. But there were already established Bill of Rights in terms of the foundational principles of English law that all the world over, or the majority of the world over, is functioning on top of. When nations, a lot of nations, in the case of Canada, did is they rewrote a whole bunch of laws that looked similar, sounded similar, but are now over top of the foundational laws. And one of the things that Judicature Act accomplished is that, and you can look at those laws as one way you can translate the term equity, or laws of equity, is these laws of nations. And I'll just leave it at that because it requires a lot to break this down and more time than we have. But a lot of nations pass a whole bunch of laws that now take precedence over the foundational laws. It doesn't eliminate the foundational laws. It just takes precedence. And the onus is now on you and I, or anybody, to show that our issue that we bring before a court, whatever the issue is, pertains to the foundational laws and not what takes precedence. When you step into a courtroom, let's just say there's a foundational law that says you have a right to something, but the subsequent laws of nations have been passed. In the case of Canada, all these new laws, like the Bill of Rights in Alberta has passed. That Bill of Rights now takes precedence, and you've accepted it until you deny it, or until you show your issue, your matter goes beyond the Bill of Rights of Alberta. You have consented to it, and as a result, it takes precedence, and it doesn't require proving anymore. When you walk into a courtroom, it's already established. And in some ways, this was required of all nations to sort of establish their own set of rules. But in not educating people, again, on the science of governments, most people won't know that there's potentially more rights available, or in the case of this Bill of Rights, in some cases, this may be suppressing other avenues that an individual may be able to have at their disposal when they're trying to go forward and make a case for something in a court of law, for example. So that's, I hope I was long-winded there, but I hope the laws of nation, laws of the land sort of was differentiated for you there.
No, it did. You explained it very well. Thank you. You've mentioned King William, the guy who conquered England. You mentioned a couple of times. What existed before he went there and stole the lands? Like, was it peace on earth and everybody had like a land patent?
No, this is so. I'm going to say something else about history. The Roman Republic, which wasn't a utopia by any means, because even in the Roman Republic there were slaves. Again, you and I, if we went back to Rome, we would not have a say. The aristocrats in Rome were the only ones that had the say. If we want to say there was an elite, only the elites in Rome had a say. Nonetheless, a lot of people look at the Roman Republic pretty highly. The Roman Republic started to fall because, similar to what's happening today, people start to distrust the people who rule them and or set laws for them, and they started to actually violate or disrespect or just ignore the set of laws that were established. And that led to the dictatorship type style of the Roman Empire. And say what you will about Caesar, maybe you like Caesar, but after Caesar, Augustus, and the ones that followed became more and more tyrannical. And then we had barbarianism. We had a lot of people that did not honor a lot of laws, and you just stole and killed. Might was power. And so that was the case until King Edward in the 600s started to very slowly try to establish some semblance of law. in the landmass that we now call England. At that time, there was different portions. There was Sussex. There was Northumberland. There was like different parts of England that went by different kingdoms. So before the Norman conquest, it was an Anglo-Saxon region. So the Anglo-Saxons ruled the majority of the landmass that we call England until King William came down and defeated him in his conquest.
I guess where I'm trying to go with this, and this is my follow-up question. You hinted at this. You said, the Roman Republic, it wasn't paradise. There were slaves. There was was there feudalism before King William? There must have been.
Yeah. We just didn't call it feudalism. So we've had, one way you could look at law, and this is a mentor of mine sort of presented this to me when we were breaking down the history and evolution of societies and laws. There was tribal systems of law, and then there was like empire systems of law. Empire systems of law are essentially with a ruler. There's a ruler that's establishing the laws for everyone to follow. We've been under some form of empire system of law for many, many, many years. And in the empire systems of law, not everyone had a right to most things. Like even during the Roman Republic, it was less than a third of the population that actually had a right to land, to property, to vote, to the ability to own certain things or do certain things. Most people were, I'm going to use the word slaves. It's not an accurate depiction, but it speaks to the fact that most people were slaves on this planet under the various different ruling or law structures that we had. So it wasn't great before feudalism. I mean, feudalism wasn't great, but even before that, it wasn't necessarily great either. What English law did, though, and what King William did, and the evolution since King William, is we started to establish some form of set of laws to govern people in a consistent way. Like Magna Carta, one of the things Magna Carta did is the lords and the barons, essentially the elites of the society, said hell and knife. I mean, it was done at knife point, but got the king to agree that, hey, listen, the king, you got to honor these laws. You can't just change your mind. If today you like me and you allow me not to pay my feudal incidences, great. But tomorrow you can't be angry at me and then take away my feudal incidences and cut off my wife's head. Like, you can't just change your mind. You got to establish some sense of order. And during the time of history that we know of, life for people has only gotten better from the perspective of law. Like today, you and I have the ability to do things that you and I did not have the ability to do even 400 years ago. And for sure, we did not have the ability to do 1,000 years ago. If you read, like Holdsworth has a 10-volume set of the evolution of English law from the beginning. And if you read it, you and I would be working the fields 16 hours a day for the king, not so that we can save for our kids, so that we can have a better place. No, we work the fields and vegetation, or for the military to create their sword or longbows. And we would do it 16, 18 hours a day with very little food, and then be sleeping in these horrendous conditions. We were peasants, we were serfs, and we were treated as such. And I use the word we because the majority of the population was in that position. But over time, law has granted people more and more rights. And so, sometimes people glorify what yesteryear may have looked like. And I had a friend who would engage with me about how Rome was great. And I had to say to him, I said, no, in Rome, there's less than a third of people who can actually do anything. The rest of us had to just, there were markets we can go to get cucumber, but it's not like I could go out and on a big, do the things we can do today.
It sounds like feudalism. It's almost communism in a pre-industrialized society.
Well, here's what I would say. Actually, the structure of English law as it is today, you could argue is communism. and I probably shouldn't say that, because then it requires me to go into detail about some things. But if you consider communism to be represented as, let's say, the Soviet Union was, which is there's a head that is making the decisions for what the community is doing, then yes, feudalism, you can look at it as communism, because the monarch decided what happened and what didn't happen. Over time, Parliament obviously started to have more of a say, and then after 1688, Parliament had to consent to everything, meaning the people all of a sudden had more of a say. But if you want to relate communism to what was in the Soviet Union, then yeah, you can say the feudalism had some degree of it looked like communism, but that's only if you consider Soviet Union as a communism, because, I mean, based on the definition of communism, which is communal living, you wouldn't have an empire system of law, meaning one person at the top governing the decisions.
I just meant like nobody owns land and everybody works for the state.
Oh yes, yeah, in that sense, yeah.
I'm going to pull on that thread. You said that English law is basically communism. Did you mean something beyond what you just described?
No, in that what you just described is still the case today. No one has absolute ownership of land. Absolute ownership is I don't have to answer to anybody. We have a use. So this is an old English term. Sestake use is an old English term. We still have a use. So everything that we own, we have a legal title to, but a legal title is not absolute ownership. What happens with English law is absolute ownership gets bifurcated into a legal title, meaning the one who has legally, under this set of laws, is considered the owner, and then equitable title, which is under this set of laws, who has the benefits and the use of it. So, and that just from right there, you can tell that we're functioning under a system of law. Most people look out society and we are living our lives. We're not realizing that we aren't living life as it is in nature. We're living life under a set of rules and laws that is established by someone else. It's not my laws. It's not your laws. It's someone else's laws that's been established that I'm functioning under. And under these set of laws, I am granted title to this property, but I don't have absolute ownership because I'm governed by a set of laws. To have this property or have this car, I'm governed under a set of laws. So no one even today has absolute ownership.
I was thinking about it, if there's ever any case where someone does have absolute ownership, and I thought as an example to cite your body, your person, but I'm guessing,
Right.
Even then, like you have abortion, you have some version of head tax. Am I right?
No. So we're getting into different aspects of law. So in law, there's different jurisdictions, meaning what you have an authority over. So there's a subject matter jurisdiction. So what I was just talking about was all the things. William Blackstone wrote the Commentaries on the Laws of England, probably the last really great book written on the laws of England. At one time when I was researching, it was the most cited author in the court system. But Sir William Blackstone would say there's the law of things and there's the law of persons. The law of things pertains to all the things that you and I in our last conversation talked about: a car, a house, things. Law of persons is the law that governs me as an individual. The laws of nations establish the laws that govern me as an individual. But no law can be passed that gives someone else the authority over my body. That violates, essentially, that violates the laws of the Bill of Rights of 1688. But that can't be written into law unless, of course, we're in some type of feudalism again, where we're slaves to someone. So as far as our body goes, yes, our body technically is not something you can write a law on to try to govern or limit in any way. That's the other thing with laws. Laws are mostly establishing some sort of limit. Like to enter society, this is the other thing that came up, over the last few years talking to people, is like this notion that inalienable rights, right? People say, I have inalienable rights. You do. In nature, everyone has absolute right to do whatever they want in nature. But everyone has that absolute right to do whatever they want. Nature is unforgiving. If you did not live in a society and, you know, you are camped out next to me, and all of a sudden I want to be under the tree you are, and you say no, great, and I have the knife and you don't, I stab you. That's where morals and ethics and govern people, but that's the law of nature. But the moment you enter a society, you're entering into essentially a compact. You're entering an agreement that all of us as a group are going to live together. It's like entering in a relationship. If I'm going to enter a relationship, I give up some of my absolute rights. I can't just go around sleeping with any woman that I want if I walk into a relationship. I've given up that right. It's no different when we enter into society. We don't give up our absolute rights. Maybe give up is the wrong word, but something takes precedent over our absolute rights. And that's where law comes in. Law establishes the boundaries to what you can and can't do in respect to everyone else in society with you. So you and I can complain and say, hey, this law limits me. Yes, that's the job of law, essentially, in some regards, is to limit you in the confines in respect to everything else in society. So yes, I'm going to limit your ability to fire a gun in public because this other member of society wants to be in public without having to listen to a gun go off or whatever. So we never lose our natural rights, but to be in a society, William Blackstone would say you give up some of your absolute rights. I would say something takes precedent over your absolute rights. And that's where the law comes in to sort of bracket your ability to have full freedom to do whatever you want.
So before leaving this, one other thing just came to mind on the concept of feudalism. In the Roman Republic, those, 1/3 of the population that could own land, they had a much stronger claim to that land than, someone working a field or like a tenant, right?
Right.
And I'm guessing that might be because they just didn't have, like, the state wasn't sophisticated enough at that point to have like digital records, and I don't know. They didn't have the power to enforce it.
I'll relate it to feudalism because it's feudalism sort of really refined that. So here's England. The king owns all of it. The king says to this lord, this portion of this England, this territory, I'm going to give to you. You can be the lord of that territory, but you ultimately have to answer to me, and you ultimately have to give me feudal incidences because I'm letting you on my land. That's where the term landlord originated from. And again, it's no different than Game of Thrones. For those that watch Game of Thrones, there was the king of the realm, and everyone had their kingdom or areas that they were lord of, territory, but they all answered under the king. So that's how it was. So that you, if you were a lord or a baron, you may have had a petition or area of land that then you had serfs and you had knights under your people. Let's say I'm going to make these things up, but let's just say you're the Sussex clan, and then you're the Essex clan, and you're Lord Sussex and you're Lord Essex. Well, Lord Sussex and Lord Essex have a territory under the kingdom of William. Let's just use William's name. They all still answered to William because it was all his. And in King William giving them a portion of his land to essentially have lordship over, they give to William their knights if ever someone wants to attack King William's land. English law really, I would say, refined this. This existed in the Roman Republic as well. It wasn't as refined. Because in the Republic, there was a republic, essentially. There wasn't an absolute king ruling. There wasn't a monarch. There was an aristocrat. And so it was set up a little bit differently. So people had, like a lord had on his territory, he had the absolute say. He was like the king of his mini little area. But ultimately, though, he was subject to the king. And he owed feudal incidences and loyalty and allegiance to the king.
You might think this is a stupid question, but at the time, did the people believe that the king owned the land, or was the king like a representative of God, and they said God owned the land?
Oh, I'm so glad you asked this question. before 1688, church and state was very tied together. In fact, English law tried to separate church and state and passed various different acts to try to separate the church's power, I would say. But no, there was the divine right of kings. So it was kings ruled because they had God's authority to rule. And at that time, keep in mind, that's the other thing that we need to always keep in mind if we ever read an act of law. Like if you read an act of law from 1535, like I have, or in the 1700s, you have to look at it through the lens of that time, not through the lens or context of today. In the 1300s, people's intellectual, moral development were at different stages that they are today. In the 1300s, there's some people that believe that if I don't follow the God's wishes, then I will be stricken to hell and to suffer. And God's wishes was what was told to me, because I can't read. So I can't read what the Bible says or what this holy text says. It's what the priest says to me or what the church says to me. And the church had strong ties with the king. And so if the church said, yes, this king has been bestowed upon us by God himself, then people naturally, because of faith and because now allegiance, they would live as if this king had authority. Like if you watch a lot of the old movies or TV shows depicting that time, there was a degree of integrity or honor in people's words, because, you know, if they swore allegiance to the king, like today, what would happen is for some people, they'll swear allegiance to someone, and then the next day when it doesn't suit them, they would violate that. Back then, that wasn't the case. A, if you violated, you had your head chopped off. And B, people's relationship to reality was different in that when they swore allegiance to something, they swore allegiance to it because faith, honor, so much respect. What was considered being a good person was constituted differently. Like loyalty was a good thing. So people just granted that to the king. But it's funny you should say that, because there's written in Holdsworth, 10 volumes that he writes about this. He goes, one day people are just sitting, managing their farms. The next day, King William takes over and someone shows up at their door and says, the Doomsday Book, which is a book that's written DOMES day, it was essentially the first land survey. He collected everything that was on the land and said, this is all mine, and wrote it down. Someone shows up to your door and says, this is now King William's, and you are now to do this and give these feudal instances. That literally happened overnight, and you had no say because they had the weapons, they had the force, so you just went with it. I mean, again, we have to try to look at that time through the lens of that time, which is sometimes a challenging thing to do.
It's fascinating. We were going to talk about the law, and we're talking about history. I like this.
Well, Payman, sorry to interrupt, but I got to tell you, like, as I tried to study law to understand it, and I went right back to the beginning and saw its evolution and why this act was passed, and then why that act led to this act being passed, and why this act was passed, and vice versa. I realized you can't separate law from the historical context. They're tied together. Like it sometimes it feels like it's not, but it is. Like even the Quarantine Act that was passed, 2003, we have the SARS or whatever happened then, and there was an issue. What happens if we have a global pandemic? Well, how are we going to deal with this as a society? We're going to pass a law to fix this issue, right? This is what law is. An issue arises, we pass a law to fix that issue. And that law that we passed was the Quarantine Act, to fix for the issue of what happens if we have an outbreak of some deadly pathogen. And the Quarantine Act never came into really full use or effect until 2020. And all of a sudden there was a situation that a law was passed for that in the past they didn't know how to deal with, but now it passed, and now it's like, okay, now we can fix it. This happened in the courts as well. There was an issue. People walk in, would say, I'm not my birth certificate, and waive their birth certificate. And some cases were thrown out, some cases were just dismissed. And it led people to believe something about what was going on that wasn't entirely true. The courts just didn't have a way to deal with it until the courts created a way to deal with it. They fixed that issue by passing various different acts, including an OPCA litigant act. And now you go into a courtroom, you do that, the judge has an easy way to deal with it. They have an act in law that says, okay, great. You're an OPCA litigant, get out of the courtroom, case dismissed. So law is always fixing for issues, and the history is very much tied to that.
Okay, well, should we continue on with the next question?
Yes, absolutely.
The English Civil War. How did that? Well, how did it come about? I don't want you to talk for an hour, but what happened and how did it impact the American Revolution?
Okay, so before 1688, everyone was, we had feudalism. We had a despotic monarchy, a monarchy that ruled absolutely. After 1688, people were freed from their allegiance. It went from a despotic monarchy to a constitutional monarchy, meaning through consent. Now, this isn't the only reason. And one could easily make the case this would have happened without this happening, this law being passed, or this change in society, the aspects of society. But it definitely changed the minds of people. Like before 1688 or before 1600s, you are subject to a king. You have no say. Into the 1700s, you're now living 70 years or 100 years where there's a consent-based relationship. It changes something in your mind. Like if you're a prisoner of someone, let's just look at it that way. You're a prisoner of someone to you being a housemate of someone. If you're a prisoner of someone, you're not going to kick them out of the house. But if you're a housemate of someone, you can say, get out of my house, right? And there aren't a lot of incidences where anybody tried to separate, a colony tried to separate from Britain or England, as it was called before 1707, until after 1688, until after the relationship of people and king changed from absolute despotic monarchy to constitutional, meaning by consent. And the moment that change happened, we had several colonies start to separate. The United States is still very unique in that they did it in a way that no other nation, with the exception of you can argue maybe Kenya, you can argue maybe Ireland, the Free State of Ireland did. No one else did, which is they fought for their freedom and then were finally completely separated. The territory was completely separated from being a colony of Britain's. So they are very unique. But one of the things I mentioned to you in our private discussion is, you could make the case that 1776 would have never happened if a law wasn't passed in 1688 to change the relationship between people and king. And then the 80 years or 90 years after that, where people's relationship in reality changed to how they view themselves in relationship to the king as a colony.
1688, the English Civil War, the Lord Protector, Cromwell, Oliver Cromwell, he wins.
Right.
And England becomes a sort of a republic, but it just didn't last very long. And they brought the king back and went back to a monarchy. Could you make the argument that America was basically just like the next line down that path, where America succeeded where England failed?
Well, I wouldn't say England was a republic. I think Lord Cromwell, he was asked to take over essentially the monarchical position but he didn't want it. And they tried to establish a committee and that didn't work. And ultimately it was decided, no, we need a monarch. Let's just change the relationship of the monarch though. Let's not have people be subject to a monarch. Let's have people have this sort of consensual relationship to the monarch, meaning they choose the monarch. It's by consent. It's a relationship as opposed to an ownership. Let's put it that way. But you could say, the United States is maybe an evolution to that. Sure. Like it was after that maybe now we're getting into discussions about a governance structure, like a parliamentary system versus a republic, or that becomes a personal choice about what one thinks is a better structure to have a society function inside of.
All right, that was easy. Moving on to the next question. I don't know if you want to comment on this. I think you already answered it, but do you want to add anything?
Just to say that, all rights, you can consider all rights as privileges. You can consider all rights as duties as well. Like they're interchangeable. Like if I have a right, I also have a duty. If I'm in despotic monarchy, I have a right to be the king and have authority over everyone, but with that right comes the duty of protecting everyone, and vice versa. If I'm a subject of the king, I have a right to be protected, just like I have a duty to swear allegiance to the king. So rights and duties are interchangeable. With all rights comes duties. With all duties comes rights. Blackstone would argue that it's actually not rights, they're duties. When you enter society, you're accepting duties to one another and to each other, not rights. But if you want to look at privileges or rights, or as rights as privileges, that's an accurate thing, because again, once you enter into society, you have a set of duties, as Blackstone would say, and you're limited in relationship to everyone that you're in society with. So society establishes what the group can do and not do, not what the individual can do and not do, but what the group as a whole can do and not do. So in that case, it is a little bit of a privilege. I think in some people's eyes, it has a negative connotation only because we have an expectation that we should have absolute 100% right to do whatever we want. But no society can function that way. That's barbaric. That's what happened during the times pre-feudalism, where we had barbarianism, and there was death and destruction, and it was not a good time to be alive, unless, of course, you had a lot of power and money.
Okay. What's the next question? This is the one I had. Like, what is a republic? Because typically, when people think of a republic, they think like not monarchy and the president is elected, not selected or whatever de facto, like our prime minister.
Right.
But what is a republic to you?
I mean, they all the different forms of government fall under essentially a democratic system where people have a say. And the only difference in a parliamentary system like we have is the executive branch gets its legitimacy from Parliament, for example, and the head of state is someone else. In our case, it's the Governor General, or representative of the King, even if it's an honorary position. Whereas in a representative democracy that's presidential in nature, the president is elected. So we elect a party, they elect a person. The person happens to be with a party and consistent with some of the values of the party. But as you can see, like, Donald Trump was elected as a person to be president, but he may or may not follow the Republican Party's best wishes or intent. Whereas here, we vote for a party, and the party is Parliament establishes who that head of that party is to sit as prime minister. And there's subtle differences. Like, our executive and legislative branch has some crossovers within them, but I used to get really caught up in this and think there is like major differences between the two. I don't know if there's major differences between the two. I think there's definitely some differences, and there's an argument to be made that in a representative democracy that's presidential in nature, that is like a republic, that you and I would have more of a say. But at the same, we still have to, in a republic, we still have to vote for a representative, just like we do here. That representative may or may not honor our wishes, just like they do here. And that representative can still be bought by corporate interests, just like they can here. So I think there's sometimes there's fantasizing about what the United States is and isn't. And I think as a nation, it's a wonderful nation. There's a lot of great things about it, but it's far from what it was when it was first established. There's a really great article that was written, and I don't have it on hand to tell you the author, comparing Canada and the United States legal system. And the argument was presented that actually the United States has become more centralized than Canada has. Canada originated as a more centralized nation, and over time it's become more decentralized. I know sometimes it may not feel that way. And the United States established decentralized and has become more centralized over time, which was a really interesting comparison that this author did, this university law professor. And if I can find it, I can forward it to you. So I think in theory, the republic establishes that maybe everyone can have more of a say, that the minority doesn't get to be ruled over by the majority. But in practice, I imagine 95% of the time it feels the same. I've never been in a republic to sort of speak confidently about that, but just from reading the law, and that's what I would say.
I always imagine that when they created the republic in 1776, they wanted it to be like property states. So like every plot of land is in effect its own state,
Hmm.
and you can violate that sovereignty of that plot if they committed like a murder or something like that. But for the most part, people could go about their lives doing whatever they want, and there really wasn't that much public land. Like the road was public, but
Right.
now like everything is public. Like I'm a Whistler. If I can just continue,
Yeah.
when I walk to the grocery store, I have to go. I go by a hotel, like in front of a hotel, the Fort Fairmont um, hotel, and just the number of bylaws that the government has come in and has put like their mark on the property. Um, like everything is public. I don't know how to explain this. Like you
I
cannot go from A to B without crossing some form of
I
government
understand.
requirement.
Well, this is again this is why I got interested in law, is because a lot of times a lot of bylaws and laws happen, and you and I could sit here and make the case if we break it down and say there's no need to have that, or that's like a limitation too far. But if there's no one there to contest it, then it happens. Sometimes people have the illusion that the courts should deal with it or this person should deal with it. Try to look at society this way. Society, in this case, Canada, is a group of people. They're all equal. Since 1688, technically, quote unquote, they're all equal. Some of the members of the group decide, I'm going to run for office and be government. Some of the members decide, I'm going to be a court. Some of the members decide, I'm just going to be regular Joe. The court is bound by their job description, which is established in the acts that establish what the courts can and can't do. The Act of Settlement 1701 established that separation and started to establish what the courts have their duties essentially for that job. Government has their acts that limit them or don't limit them. And the people who limits government is the people, is the rest of us. If you and I if we have a group of 5 friends and one decides to be the leader, one decides to manage the money, the three of us, if we think the one who's being the leader is taking us astray, well, then we all have to get together and say, listen, we don't actually think you're taking us the right way, and kick him out as a leader. Society's set up that exact same way. Most of us, unfortunately, because we're nescient of the laws that bind us, we don't know what to do. We don't know what to do, when to do it, and how to do it. And sometimes feel like we can't do anything about it. And so time passes and laws are passed and bylaws are passed. And some of them probably are ridiculous bylaws. And I would argue that a lot of them are probably ridiculous bylaws and they become money-making schemes for this city or whatever. But no one's there to actually try to limit. I mean, I think I see a lot of people trying to educate themselves and be that way to society, which is a good thing. That's what we need to do. We need to be informed on what are the rules of this game, of this society, and try to hold everyone accountable. Because if we don't, greed, lust for power, all this stuff that, if we want to call them the 7 deadly sins, they exist. And so people could succumb to them. And if no one's there to restrain them, they'll run amok and they'll pass several bylaws to make their financial requirements instead of finding other ways to do it, let's say that are within, that don't violate maybe their authority.
It's an interesting view. I guess it doesn't help that everybody is like in debt and they're just trying to stay afloat.
100%. No, 100% for the people that want to argue that, a lot of this stuff is done intentionally to keep us at bay. I'm not going to argue against that, and that makes complete sense. Like we're in debt. We're just trying to survive, that we don't even have time to devote to these other things.
Well, Mark, I guess we're down to the last question. Probably an easy one. You mentioned they can't like all. I think you said all constitutions are acts. They don't just come out of nowhere. Can you
Right.
describe what you mean?
Right. So one way you could look at law is it's an agreement between men, right? So if we are saying that we're going to constitute ourselves as a society and we're going to establish certain rules, we're making an agreement amongst each other. We're making an act. So that's one way you could look at it. Yeah, everything, we're under English law, right? We're not in nature. We're under English law. We're under the rules of English law. And English law says that for something to be law, an act, something has to be written about it. And that's essentially what a constitution is, a written piece of law or an act or a statute, whatever you want to call it, that is essentially being passed to grant authority to that written piece of paper. The Declaration of Independence has no legal authority to it. It's just a group of people saying, hey, we're declaring that we're going to be free. But nothing got constituted in law until they formulated a group of people who would be essentially their government to write laws for them, the legislature, and then pass an act of law, their first act of law, their first act as a society to establish the ground rules for themselves. So all constitutions are acts of law. Some constitutions are a single written act of law, like the United States Constitution. Some constitutions are a series of acts of law that happens over time of the existence of that society that starts to establish the ground rules for how to conduct yourself in that society.
Something it just occurred to me. You mentioned everybody's living under English law. Is there anywhere that they don't have English law? Like, is Islamic Iran under English law?
So the laws of the land versus the laws of nations. So from my understanding, and I can't read Farsi, but from my understanding, they also function under the basic premises of landholding or the common principles of law in Iran as everywhere else in the world. Same with China. Now, their laws of the nation happen to be theocratic in nature, are different. But the foundational principles that the rest of the laws are built on top of are English, from my understanding. And to really fully appreciate it, I have to sort of break this down. We got to go through some history, and it probably will take too much time. But if I did have the time, you'll see exactly what you mean. The basic foundation is there, and then all of the nations built on top of that, essentially. And so the English law established the basic foundation. There isn't a place I don't know of. I haven't come across a place that functions under another set of laws. Maybe North Korea. I don't know, because I haven't seen any of their stuff. But when I looked into China, when I looked into Russia, when I looked into US, Canada, and even looked into the Middle East and different places, I didn't find somewhere or something that would suggest otherwise.
They emerged organically, or did they all adopt the policy of England?
No, it's so that's another great question. So there's certain rules, right, to the field of English law. One of the rules is the reception, and a really famous, I shouldn't say famous, a really well-written author, Cote, wrote about this in Alberta, at the University of Alberta, and this is where the rules of reception comes in. So when for example, when colonials or subjects to the king came over to this landmass that we call Canada, the rules of reception stated that the moment any subject went anywhere, they took the laws of England with them. And so if they went somewhere and then started to reside there, they established the laws of England. Obviously, this is like a weird thing because there's other laws there, like the natives had their own tribal systems of laws, but this is where force and power directed things, and the British Empire was the strongest force, and they just said, no, this is it. In fact, same thing, Holdsworth, or this may have been Maitland, I forget, but I think it was Holdsworth wrote about this, that they just ignored those other laws as if it didn't exist, because to them, the only laws that existed was English law, and in English law, it's written that wherever a subject goes, they take the laws of England. So if they go to
I'm sorry,
far off land,
I'm a little bit confused.
Yeah.
Isn't that an example of something that doesn't apply today?
Say that again.
Like, if I go to Mexico, I don't bring Canadian law with me.
No, so that's laws of nation. So when we're talking about English law at this point in this conversation, I'm talking about the foundational aspects. So now you asked me, is this something that all these other nations just accepted? And so I was sort of detailing the laws of reception. And so the laws of reception is when a subject goes somewhere, they take the laws of England with them. Or the other way is you adopt a portion of a law. So let's say Russia says, you know what, we like the way the England, or Britain as it was known after 1707, has their laws to land holdings. Like I like the way they do property law. The moment they adopted property law under English law, they accepted English law and received English law in all its principles. And so this is a quality of English law. It's not a quality that's of nature. So this is English law just sort of wrote this in, and a colonialist would do that, like the power empire of the world would do this. But essentially, if you use a portion of English law, you're accepting all of it. And so the foundational laws, you accepted all of it. Now, Russia, in this case, I'm giving Russia, but let's just use Canada. Canada wrote all its additional laws on top of the foundations, but the foundational laws were accepted. So even the 13 colonies of the United States, they declared independence. You could say they got independence from the Parliament of Britain to not write laws for themselves, but the foundational principles of English law were received, and each one of those first 13 colonies passed an act stating so. And they call them the reception laws, essentially the act of reception. So the original 13 colonies received and they accepted all the foundational laws of England, essentially, and then they built laws on top of it.
Jeez, this has been a massive learning campaign for me the last hour, so hour 10 minutes. Thanks.
Yeah.
Obviously, we have to get you back on to go into this. Like, I'm still a little bit baffled that we can have a principle like this in law.
This is again where history comes in. This is where everything turned for me, and I start to appreciate and understand geopolitics differently as well. But I would argue that this is the fundamental thing that most people miss or have missed, and I can't take credit for it. There's a mentor of mine who spent 10 years in law libraries just reading footnotes and tracking footnotes to sort of see this, but this is all public. It's in our face. We just don't see it. Anyways, yeah, it is. And once you see this, you sort of start to see society a lot differently. It's very much like Matrix and the Neo in the Matrix, where you start to see things very, very differently afterwards.
All right. Whenever someone cites the Matrix, it's time to wind it down.
That's right.
Do you? I don't know if you have a social media presence, people can follow you, or do you want to leave it with a final comment?
I don't have a social media presence at all, and I'm rather not be on social media, but I will share this. Myself and a group of people have been working on trying to distill. We've spent collectively, 25 years in law libraries and reading textbooks, like I said, volumes of Holdsworth, Maitland, Cook, Littleton, Blackstone. The average person is not going to go read these books. So we've tried to put together some place where people can go and start to get some of the information to learn some of these things in a much quicker and much simpler fashion. And the site is not complete, but maybe I can share with you the URL for the site. Hopefully next week or two will be complete and people can go on. And we've tried to really shortcut the learning process and for people who are interested to understand not just the laws of Canada and where you can find how the structure of things are and where your rights are found and all that stuff, but even sort of the evolution of how we got here today, and potentially if we wanted to change it, what can be done. So I can provide that URL or send it to you and you can share it. I don't know how you want to do it, but that would be what I want to share.
Probably would be best if we could get you back on whenever that's up. And I don't know if any of your partners want to come on. And also, if there's any way else I can help, like if you want to get on somebody else's podcast, I'm happy to help that way too.
That would be great. Yeah, I appreciate it. Thank you, Payman.
Well, Mark, I thank you so much for coming on. Thank you for having the patience with my simplistic questions. And I hope to see you back on sometime.
Thank you very much. I appreciate you having me on. It's good to have these kinds of conversations, I believe. So thanks for having them.
Anytime. Take care and goodbye, everyone.